Hey law students, Professor Orenberg here. Today we're going to talk about briefing a case, a really important skill in law school. Briefing a case is summarizing the cases you're learning in class and organizing that information in a way that you can access later for your notes, for studying, for practice. Case briefing is what lawyers do when we do case law research. Before you get started, I'd like you to do two things. One is, please access the case brief template. I don't have the secret sauce to the world's best case brief, but I've researched a lot of them. I've done a lot of these myself, and I've put together a PDF template which looks like this. And I say this is an advantage. By design, it forces you to keep your case brief to one page. That can be a challenge for some of you, but it's not a brief if it's long. So check that out and read Chicago Medical School versus Steinberg. I'll put the reporter citation down below, but we'll be talking about that case. So if you haven't read it yet, pause here, go check out the case. It's a great case, a good case for everyone who's looking to learn how to read the law, to get started. It is a case about contracts. It's not that complicated. It's not very doctrinaire. It regards a situation all of you students are familiar with, which would be admissions to an academic program. So I hope that this is a useful case for you to start with. And once you've done that, and again, pause the video here if you haven't obtained the case brief template and haven't read the case, go ahead and pause here and do that. Try it on your own. Try to fill out the case brief template, and then I'm going to show you what I did to brief this case and compare it to what you did. Maybe you'll learn from some of my strategies. That's my hope, at least. So let's jump in and let's talk about the components of a case brief. So according to my template, which is really not that unusual except for the fact that it's kind of programmed. Most of these you'll get on Word, but PDF gives me some features. What does a case brief include? It's going to have a citation identifying the case. It's going to name the parties who are the litigants, discuss any other entities, any other people that are involved in this dispute, talk about the procedural posture, the civil procedure, or in some cases criminal procedure, the procedural history of the case. It'll describe the issue, which is the question, the answer to which will resolve the case. It'll present the holding, what did the court decide? It'll go through the rules that the court pronounces, and most cases will either reiterate rules that are worth remembering, or will actually produce new rules that you can use in the future. For the most part, the cases we read are reasserting rules that are established in treatises and other places. We have a section called facts, and facts are going to relate to some factual information that happened in the case that provides useful background, application, the arguments the parties made, and the conclusion, how did the court rule. By the way, this mirrors really closely the IRAC paradigm, a paradigm for writing legal analysis. So guess what? You're starting with reading and analyzing and understanding legal analysis, and you'll graduate to writing it yourself. So again, we'll jump in. Let's start with citation and then work through the elements. The citation to a case can be written a number of different ways, but it has a couple components. First is the name of the case, here shown in underline or italics, which are the conventions, followed by a comma, which is not italic or underlined, by the way, for those of you who are going for law review. Get those little details right. After that is the reporter or reporters, where the case is located, how to find it, and then the year, sometimes the court. There are a lot of different ways to write a case citation, and one of the simplest ways to do it is to include all the reporters. So you see that in the first two illustrations. The reporters here are the Illinois 2nd and the Northeast 2nd. ILL 2D stands for Illinois 2nd, NE 2D is Northeastern 2nd. All that means is that this case was important enough to be reported in two different journals. So back in the day where people used, books, cases were published in books, believe it or not. and you would subscribe to an edition based on the area of law you cared about. So some people would subscribe to the Illinois Reporter because they practiced Illinois law, others to the Northeastern Reporter because they practiced in that region, and some to both. This case was important enough to be published in both. So which one should you list? Well, I mean, you could make it easy and list both of those because they're both places to find the case. But one of them is more informative than the other. You see, the Illinois Second Reporter only reports on Illinois Supreme Court cases. If you happen to know that, that's cool because it means you can actually list the Illinois Reporter, and that implies the court, so you don't have to list that in the parenthetical. So the shortest possible way to write the citation for this case is to reference the most specific reporter, the Illinois Reporter, and then you don't need the name of the court, the Supreme Court of Illinois. Of course, all of these are accurate and all of these are fine. So that's just probably an aside on some strategies. But look, as you get into practice and as you get into preparing for practice by being a law student, you want to think about how to organize your material. So don't just randomly put letters and numbers after your cases. Make a decision based on how you want to organize your information. Do you want to pick the reporter that is the most specific and therefore gives the most information, requires the least additional information? Or would you prefer to use a reporter which is probably more subscribed to, more general? You're making decisions about lawyering already here in the citation. Any of these are fine, is the truth of it, because if you went to Westlaw and you typed in 69 Ill 2nd 320, you'd get the case, and that's the point. Can someone who has this case brief access the case? Next, you want to have a short version of the case. The convention is whatever name comes first, that's the name we're going to use for the short version of the case. Now, names switch as litigation proceeds. So if a party, some places will use the plaintiff as the first party and the defendant is the second, but if the case is appealed, let's say the defendant loses and then appeals, now the defendant becomes the appellant, and that will become the first name in the case. So since the names in cases alternate, I would say use the short citation of whichever the party's names is more evocative, more memorable. In this case, Chicago Medical School, to me, is more evocative. So I'd go with something along those lines, and you can, of course, use a abbreviation for that as well. But there are some conventions around this. However, I think the key thing is identify the case in a short way and do it consistently. Who are the parties in this case? Well, this is a simple case, as I mentioned. Well, not that simple, because it did get to the Supreme Court level, but we have a plaintiff, Robert Steinberg, and we have a defendant, the Chicago Medical School. Now, I'm not going to get into the civil procedure of class action. It happens to be that the plaintiff had a class action as well. So we're going to mention that in the parties. He's on behalf of the class. But notably, I think the key things are who's the plaintiff, who's the defendant. The plaintiff is the party bringing the case, who is making the charge. The defendant is defending against this. In this case, Robert Steinberg brought the case, claiming that Chicago Medical School breached a promise, making CMS the defendant. But importantly, by naming Robert as the appellee and CMS as the appellant, we know that Steinberg won at some previous level. That's important. See how much information we're getting just from citations and parties? I mean, you can learn a lot from a case brief if you know what to look for and if you're organizing in a thoughtful, orderly way. So anyway, Steinberg, he was the winner at the previous level, and here we are at the Supreme Court. So it's really up to CMS to make their case as the appellant. So the shoe is on the other foot, as they say, and that's nice to know, and we want to identify that with our parties, where we name them and provide their situation or status in the case. Other entities can be zero. There can be no one else involved, or there can be many people involved. Here, There's a whole other class of people. It's a class action. So for our purposes, we'll mention that there are other class members involved because many applicants applied to Chicago Medical School, and all those similarly situated people are going to join the class and be party to the same suit. Procedural posture tends to be hard for early students to understand because, quite frankly, you're learning Civ Pro right now. So I don't, and no 1L professor should expect you to really get the procedural posture in your first cases. But it turns out that procedure and substance are really intertwined, and procedure is really important. It's how you effectuate your rights. So what's going on here? In this case, what happened at the trial court level was that, well, like every trial, the case began with the plaintiff filing a complaint, and after the complaint was filed, the defendant had two options: to answer the complaint and proceed with the suit, or to move to dismiss the complaint. There was a motion by the defendant to dismiss the complaint, which was granted by the trial court, ending the case at that early stage. Now that's important because actually it's kind of a big deal to have a case dismissed that early. That means that there really aren't any factual issues to even explore. As a matter of law, the plaintiff lost at this early stage in the case. So if the decision gets overturned, if the case gets decided for the plaintiff in the end, or if we reverse, all we know about that is that this was not a good case for dismissal. It's not really a win for plaintiff. I mean, they win this stage, but the procedural posture of this case is early, very early. So the fact that it won't be dismissed isn't that big a deal. It doesn't tell us that much about what makes for a good claim. It just tells us more about what's not bad claim. And this is actually a Supreme Court case. It got reviewed by an appellate court who reversed the trial court. So we are now in a position where that motion to dismiss is overruled, not granted, and the Supreme Court is going to look at that de novo as new and establish whether that motion to dismiss should be granted. Look, that was probably a lot of information for new law students that you didn't necessarily know, but you will. And as you learn about civil procedure, you're going to get better at case briefing because you'll understand the procedure of the case better as we go through that. Anyway, it turns out to matter. At this stage, do your best. Do your best to fill in this section. No one expects you to be an expert on civil procedure before you've taken the class, but do try to identify the procedure of the case because all I can say for now is that it matters from a substantive perspective because what we have to prove substantively depends on where we are in the case procedurally. All right, let's get into the real essence of what you can and should be doing well now. Next up is the issue statement. And the issue statement is something that is hugely important at this stage. This may be the most important part of your case brief for your first month of law school. Can you identify what legal issue is raised by a certain set of facts? It is so essential for you to identify issues that are raised by facts. Otherwise, it's so hard to do the rest of the legal work. If you don't know what issue is raised, you won't know what facts and what rules to consider when evaluating the answer to that issue. You didn't spot the issue. Spotting the issue is where it's at. Issue spotting. So right now in contracts class, we're at the very beginning. We're talking about whether a contract was formed, and unsurprisingly, the issue is whether there was a contract. And that actually, I think, breaks down into two components. Whether there is a promise. A promise is an aspect of a contract. All contracts require promises. So we actually might even go deeper onto that sub-issue, whether Chicago Medical School made a promise, and secondarily, whether that's an enforceable promise. Now again, civil procedure matters. These are legal questions. These are questions that can be decided as a matter of law without really reviewing much, if any, of the facts of the case. And that's because of the stage of litigation. Now, I don't expect you to know all this stuff yet, but I do want you to be sensitive to why we're asking this. Your case briefs at the beginning won't be perfect. They may not even be great. But the important thing is trying. The important thing is to try to make an excellent case brief from the get-go. And the way to get there is not by writing a lot. Less is more. It's a brief, short. You may not hit the issue on the head. That's okay. It's why you come to class with your brief. Being prepared, being flexible to reconsider what you decided. Anyway, the issue, that's the question, the answer to which will decide the case, it is so important for you to recognize, because then you will know why we're reading this case and how to answer it as a matter of law. So, again, this is issues regarding to the case, which if you haven't read yet, pause, go read the case. This whole lecture doesn't make much sense without it. And moreover, hopefully you've already tried to spot these things yourself, and maybe you have some other issues to raise as well. But these are the contracts ones. These are the ones that are pertinent to our class, our case. A holding is a court's decision on an issue. What did the court decide? And here there are two issues, so we're going to have two holdings. Basically, kind of briefly explain what the court decided. A holding could be as simple as yes, no, if the question is phrased in could be answered with yes, no. Because really the holding is just the answer to the issue, and the issue is the question that will decide the case. The holding is the decision of the case. I tend to write a little more in my holding statements, a little bit more fact and reasoning. You might call this reasoning. Whether these reasoning components go here in the holding or whether they go in the application, they don't go in the application for reasons you'll see, whether they go in the conclusion. People have different approaches to where to put this analysis, but since this is the court's analysis, not a lawyer's analysis, I think that the court's analysis appropriately does go in the holding. It's the explanation for why the holding was made. But again, the holding is the resolution of the issue, and the issue is the question that decides the case, or questions. So in this case, the holding, the first issue, as I mentioned, was whether there was a promise, and the first holding was yes. Yes, that statement was a promise, and here's some reasoning why. As I said before, I tend to put the reasoning along with the holding because it helps me understand the holding, and it provides that context in a place that makes sense to me, but really this could be part of the conclusion as well. But note, these are court analysis. This is what the judge thought, not what the parties thought, and not factual background, but actual court analysis. We had two issues in this case. As a result of having two issues, we're going to have two holdings. There should be one holding for each issue, unless for some reason, which is weird, the court didn't decide an issue. Maybe it decided the issue was moot. The second issue was whether there is a contract, and the answer is yes. By the way, holdings are answers to issues. Issues are questions that will resolve a case. So in this instance, the holding is yes, there was a contract. Yes, it's an answer. We're going to answer that dispositively, yes or no. Once again, read the case for more on what I mean by this holding. You can read this up on your screen, but this is not meant to teach you the Steinberg case. This is meant to teach you how to brief a case in general, in all your classes, not just contracts. So that's the holding. The holding is the court's answer to the legal questions you identified as issues, issues being disputes the court must resolve to resolve the legal dispute. The court resolves those disputes with rules. I tend to cut and paste rule statements right from the case. And sometimes the court does the same thing, cutting and pasting rule statements right from the Restatement of Contracts or a treatise. We see several of those elements here. Sometimes the court is just saying things that are so, I want to say obvious. They're probably not obvious to novices, but for anyone who does contract law, the statement that an offer, an acceptance, and consideration are basic ingredients of a contract is not news. It's not news. It's not. It's nothing. There's nothing new here. But it's something we say. We don't leave those stones unturned. And it's worth cutting and pasting some of those statements of black letter law that the court is reiterating so that we are able to remember that when we read our case brief. So the rules section, once again, is the principles the court used to make its holding. It's not analysis per se. It's really saying what the law is. None of these have any specific facts. All of the rules are abstract in that sense. They're removed from the facts, at least one level. Some students complain that rules are hard for that reason. Well, I don't know if they're hard or easy, but they're abstract. I'll give you that. They're not tied to a particular factual reality. They are the Platonic ideal. They are a symbol. They are a concept. So let's capture those concepts and let's see how they apply. And I think they'll make sense when you see them applied many different times. Up next are facts. This case was a motion to dismiss procedure. So that means very early in the litigation. Early in a litigation, there's not much time to develop factual knowledge or background. As a result, the facts are what we call thin. There aren't a lot of facts. The facts are actually really straightforward here. Chicago Medical School issued a bulletin to prospective students saying it would review applicants in a particular way. And the applicants claim Chicago Medical School didn't do it, broke its promise. Now again, the questions behind these facts are, was the bulletin a promise? Was that promise accepted in the form of a contract? Those are the analytical points we'll need to resolve. But the facts are simple in this case. Some students, they just want to write the whole story. Well, you can. But then what happens when you go back to this little sheet at the end of the term? I mean, that's what you're doing this for, right? You want to study, you want to learn, you want to get an A in law school, right? Or at least a B, right? You want to pass law school. That's why you're doing this, I imagine, at least to some extent. So if you have facts that are pages and pages and pages long, when it comes time to study for the exam, have you really done yourself a favor? You now have pages of your own notes to read. Much better to take this time to crystallize what's important about a case, condense it to its essence. That's what you should recapitulate here. So these are my facts for Steinberg. Pretty minimal. The application section, well, this is really, I'm doing my own thing here. I can't tell you this will work for every class. In fact, I never tell you anything will work for every class, but my approach, which worked for me in all my classes, and works for my students in my class, is that my application section is how did the parties argue the case? Yeah? The application section of my brief is how did the parties argue the case? What did plaintiff argue? What did defendant argue? You see, when you read a case, the parties have done the work for you. They have come up with the best arguments. All you need to do is identify them and learn from them, for sure, and see which failed and which succeeded and why. That's going to help you in your lawyering journey. But the application, it's not hard. There are things the plaintiff claimed. The plaintiff said, Chicago Medical School made a promise and it broke it, so pay me money. That's really the application. That's basically the argument they made. They made a promise, they didn't keep it. The defendant contends there was no contract, there was no meeting of the minds. Honestly, the defendant doesn't have a strong case here, so we don't spend a lot of time on their application, but that's how I use the application section. Plaintiff argued, defendant argued. There are almost always two parties in a case, so let's see what they had to say. At this stage in your legal career, meaning early, try to learn from what experienced lawyers have done. They presented this case at a Supreme Court level. Maybe you'll do that someday. But until then, or at least until you finish first semester of 1L of first year of law school, you might simply reiterate the arguments they made. And let's see how the judge evaluated them. Maybe you can also evaluate them independently. And there's the conclusion. The conclusion is the judge's evaluation of this case, of these arguments. Which argument was stronger? Which should prevail? Which should win, and why? The conclusion of this case, as all contracts cases will come out, is that secret intent is immaterial and there was an objective promise made. Whatever Chicago Medical School thought it was doing with the bulletin, objectively it looked like a promise and it was accepted. And at this time, in this jurisdiction, and under these circumstances, it's pretty clearly a promise that was broken. Well, that may have been broken. We're going to remand the case for further proceedings to decide if the promise was really broken or whether that was an empty claim. We're not dealing with the facts here. That's where the procedural posture comes in. The conclusion is how the court ruled. It's not very different from the holding. And it may confuse students. What do I do with the holding? What do I do with the conclusion? Well, if you really want to make one thing and one another and keep them separate, I would again say the holding is the answer to the issue. Right? The holding is the answer to the issue. The issue is the question that will resolve the case, the legal issue that will resolve the case. Whereas the conclusion is the balancing of the arguments in the application section. Which of the two parties' arguments were better and stronger, and why? We might think of the application as having two parts, defendant's argument and plaintiff's argument. And the conclusion is the court's synthesis of those arguments and its thesis on which is the correct and appropriate course going forward. So that's my version of a case brief. We covered the citation, the parties, any other entities involved, the procedural posture of the case and why it's important, the issue, which is the legal question, the answer to which will resolve the case, the holding, which is the answer to that question, the rules, which are the black letter statements of law that allow the court to render its holding. The facts are material facts that are not otherwise captured, again, keeping it short. The application, I tend to identify what arguments the parties made, what arguments the defendant made, what arguments the plaintiff made, and what reasoning supported or backed up those arguments, and finally the conclusion. How did the court decide this case? Which of those parties' arguments were stronger? Not a simple yes or no, but a statement as to which of the claims prevail, what relief was granted, and why, and to a certain extent what happens next, right? In this case, the case being remanded. Now, case briefing is not something you will do for every case, every time, but at the beginning of law school, I think it's a great idea to brief cases. Do it in a fulsome way. Use a template, use a Word document, use a notepad, whatever you got to do. But write down these elements. They don't have to be long. But think about what these different sections mean. And folks like me who have thought about this for a while have used this paradigm, which includes IRAC, which includes the IRAC writing paradigm, as the most effective way to collect information about cases and to learn from them. So before you reinvent the wheel, I hope you consider this video and think about whether this method will help you. So thanks for tuning in. I'll see you next time.